A deposition is part of what we call the discovery process in a lawsuit. The first phase of the discovery process is written discovery. That's where the two sides answer written questions from the other under oath, called interrogatories. Both sides have a right to request or subpoena various documents. But a lot of times after those written information and the documents have been exchanged between the sides, we move on to the oral discovery phase, the deposition phase. Deposition is simply a question and answer session where the attorneys get to ask a witness or a party to a lawsuit questions under oath in the presence of a court reporter who transcribes every word that is said during the deposition. It should not be a stressful process. Really, it's an opportunity for the attorneys to ask people questions, not in an effort to try to trip them up or track them. It's not some Perry Mason cross-examination situation. But what it is an opportunity to discover what that person's sworn testimony under oath is going to be prior to trial. One thing that all attorneys, including myself, hate, we hate surprises at trial. That doesn't help anyone. It's important for everyone involved in a lawsuit to understand and have an opportunity to fully develop his or her case before you get to trial. That way you get to make better decisions and better strategic decisions about how you want to handle your case along the way. When people are deposing my client, I usually give them some very basic instructions. First thing is always be honest. You certainly don't want to misrepresent anything intentionally, and certainly make every effort not to do so unintentionally. That's why I give the second instruction. Don't guess. If you don't know the answer to a question, there's nothing wrong with saying, I don't know. Don't volunteer a guess that then the other side can research and prove that you're wrong. If you don't remember something, it's perfectly fine to say, I don't remember. It's very hard for the other side to ever indict you or contradict you when you say, I don't remember something. A deposition is not a memory test. It's not expected or reasonable, in my opinion, for our injured clients to remember what doctors they went to on what dates and in what order and what they told this person 2 years ago or what they told that person 8 months ago. The medical records should speak to those issues. So if you don't remember something, say I don't remember. The risk is if you answer a question and then the other side pulls out the medical records and those medical records contradict something you've said, the other side's gonna try to paint you as being dishonest and attack your credibility. Final instruction I usually give clients, try to keep your answers as short as possible. Some clients mistakenly think that a deposition is their opportunity to shine and persuade the other side that my case is so great, you should just roll over and pay me a ton of money. That's never gonna happen in a deposition. I've been doing it too long. But you just wanna get through the process. Deposition is only gonna help the other side. It's not gonna help us, because in the event that we try your case one day, you're gonna be our star witness sitting right next to us testifying live to a jury. We're not gonna read your deposition transcript to a jury. So the less you say in a deposition, the less opportunity the other side's gonna have to attack what you have to say. Depositions can range from, I've had depositions that literally take 5 minutes. I've had depositions that have taken 10 hours. Most depositions of an injured plaintiff take in a range of 1 to 3 hours. And similarly, attorneys like me, plaintiff's attorneys, we're deposing witnesses who saw the crash, who witnessed the fall, employees of a business we're suing, things like that. So there may be one deposition before we move forward with the case. There may be many, many depositions. So hope that gives you a rough outline of what to expect with a deposition. Feel free to learn more through our website at trialpro.com, and you're always welcome to call us at 1-800-TRIAL-PRO. Thank you.